This is the weather that you like, Crosby. Nice and cool.
It's a good weather. It's a good weather to think. I mean, although things may not be going very well, if the sun is not hot, you're calm. You know that when the sun is hot, your anger levels increase. Good
morning. What is good about the morning? Because the sun is blazing.
The manages the water in your mind is reducing it.
Well, the NPP minority, I don't know if they're benefiting from this cool weather. At least from this morning, I've seen from a good few number of minority MPs some serious reservations, condemnations, reprimands against the president, and in fact the entire process which concerns the Chief Justice. If you're watching us on Facebook, you'll see that a release. Crosby, please do us the honors.
Okay, I'll read to you the release from Felix Kwachifosu, but let me read this one to you. So this is a comment from Kofi Asare. So he says, when Charlotte Osei was removed on 28th June 2018, he says, my people happily defended Nada's decision, talking about President Nana Akufo-Addo. NPP's Gabi said Nana Akufo-Addo had no option than to respond to the constitutional mandate. It processes the facts and the truth. Now, Dr. Mustafa Hamid, he cautioned against any attempt to politicize the EC chair's removal since it was in line with the constitution. In fact, the Ashanti Regional Chair of the National Peace Council, Professor Puni, he said the president only followed the constitution. So the NDC at that time should not blame the president. Now, that same Thursday night, an angry national organizer of the NDC, Kofi Adams, he addressed a presser at their headquarters, and he said our democracy and independent institutions were under attack. He announced a demonstration the next day. He says that today, similar event, same script, different actors, different roles.
Okay. Interestingly, okay, before that, some more reactions. So Vincent Echo Asefwa is MP for Old Tafo. He's also penned something. It's fairly long, so I won't be able to read it all out. But Edema Agbana, his colleague in Parliament, has quoted that particular tweet, and he says, this is comedies. He said, thank you, our job is stressful. What you're doing is comedic relief. Or some of you haven't taken kindly to the banter, the back and forth, but Johnny, the opinions are many, and depending on which side of the coin you are looking at, there's either, praise for how the constitutional exercise has progressed so far, or there is condemnation.
Absolutely. And for me, you see, I saw a video of the former Chief Justice, or if you like, the suspended Chief Justice, not the former Chief Justice, so forgive my slip. Talking about...
You are forgiven.
Talking about the fact that, you're a Christian mother, so I take it that you are forgiving me.
Most certainly.
Yeah, Sixtus is surprised that there's nothing wrong with it because you took it closer to the mic.
In fact,
he's not a Christian father.
He's not a Christian father. He doesn't understand what's going on.
Johnny, I heard you calling on different religions this morning. He said that Hare Krishna should rise and everybody should rise.
Everybody should stand up for them. They are Christian brothers and sisters.
Girl power.
Yeah, girl power.
And I'm reading the thing on Helen's diary.
Yeah.
Yes.
Is it well duff?
Jenny.
This one is power to the
girls.
Power to the girls.
Yes. Girl power. Okay,
Aisha, yes,
yeah,
Aisha Ado, shout out to her, doing wonderful things. This is where all their poddy.
She also does well duff. So.
Okay.
But they have also not spoken.
Duff.
They have also not spoken about them.
Oh, we know Lois from Wildaf.
Has she spoken?
I've not. In fact, I've not even seen Lois this year.
It's not Lois, so I'm talking about the institution.
That's the one I know from Wildaf.
No, but I'm sure that all these institutions that you are referring to, they are all following the process. Because you see, this is a procedural matter.
Indeed.
Is it the theory that's been put into practice?
It is a process depending on where you're looking at it from.
Yeah. I think I don't know whether Six and I are twins.
I am trying very hard to stay on the matter.
I'm with you, Six.
Tell him not to draw me into
which of the hymns?
Because Sixtus, do we need to hear from? In fact, now I'm even tired of hearing from everybody. Wants to add their 2 cents.
You see, it would have been different if there was no due process. If the processes as laid down by the Constitution were not followed through with.
Or it was difficult to understand the process.
Or it was difficult to understand the process. But if the Constitution says upon the receipt of a petition, these are 5 steps that the receiving authority must take. So question number 1, are those steps spelled out? Question number 2, are those steps clear enough? Question number 3, is the receiving authority, i.e. the president, following those steps? Question number 4, has the president, the receiving authority, deviated from precedent? Because this is not the first time we are receiving such petitions. We've had petitions for removal of chairperson of the Electoral Commission. There was a chairperson of
Shraj, that's
these are both constitutional bodies, independent constitutional.
You mentioned
bodies.
Shraj. Interestingly, the petitioner there, that was Frank Anodompre. In the removal of the Shraj, but I believe so. This morning he's quite vocal on socials. It just casted my mind back. Small digression. Please continue.
Okay, so guided by that precedent, are there any deviations we are observing in the current process by the president of today? That's His Excellency John Dramani Mahama. So these are the questions for me that we should be asking. And we have to ensure that Her Ladyship, the Chief Justice, gets her day. It's not something that anybody can play with. There are allegations against you. It is your inalienable right to be heard on those matters. And you must be heard on those allegations. Is she being given the fair hearing? Is my lady in any way being gagged? Now, there are also people who are trying. One of the callers brought this up this morning, and that's not the first time I'm hearing that. The processes that we are seeing, the Constitution also guarantees maximum secrecy.
Yeah.
It says that those proceedings must be in camera. And it is not just about the hearings of the committee. The in-camera-ness of the process is the entire process. That is why, till now, we are not seeing the petition. We don't know the content of that petition or those petitions, because the Constitution says that we must not know. We, the people, must not know the content of that petition. It may come out later on. Somebody may, in this era where people believe in information flow and all of that, somebody may, or for even some mischief purposes, leak that document or those documents. That is another conversation to be had. But the Constitution says that we must not know the allegations against my lady. My lady, however, should know who is accusing her and what the accusations are, so that she can respond. So question again is, have those been withheld from Her Ladyship? If not, then again, what are we going on and on about? So I think that we should be interested in due process. I am interested in due process as a student of the law. I want to be sure that if Helen tomorrow gets appointed as chairperson of the Electoral Commission, head of Shraj or NCCE, or a Chief Justice of the Republic, or any other constitutional body for that matter, and the Constitution spells out processes by which you must be removed from office if the need arises, then you must enjoy the full protection of the Constitution as stipulated. That it is not because the president of the day doesn't like your face, or that you have gone to hear a case against or involving the president or the president's relation, and the president was not happy with how you treated that particular or handled that particular case, and so the president is coming after you. That cannot be the case. That is also why the president is not the petitioner. Okay, again, we don't know who the petitioners are, but can the president be the petitioner in this case is another question of law. The president is a citizen, may as well turn out to be a petitioner in this case, but is it the fact that the president is a petitioner in this case? We can safely say, at least from all the conversations that we have seen so far, that the president is not a petitioner. And in this case, the president remains a conveyor belt. I made that same statement in other petitions and processes. Just before President Akufo-Addo left office, there was a petition against same leadership. I made that same statement that I believe, my reading of the Constitution, that the president is but a mere conveyor belt. And I believe same to still be true even today as we speak. So I think that there's a lot of partisanship or partisan politicization of the matter, which is not helping
because
us.
You are talking about procedure, but there's a large chunk of the Republic that is also looking at it from a political lens and also drawing from history. And you know how things go in Ghana. We can't separate the politics, it appears, from the core matters. And that is why this morning, when you go on X, for example, one phrase that we saw this morning on the Daily Gist has been replicated by Honorable Frank Anadompre. He calls it a judicial coup. These are the words that are being bandied about.
Indeed, there's a statement. The minority issued a statement.
In fact, there's a statement. We'll pull that up as well. But Crosby was just going to read that official communique from the presidency that speaks to the suspension of her ladyship. Then we can quickly listen to the Deputy Attorney General, Justice Stremsai, and then hopefully jump onto the phone lines and then get some better particulars, flesh out this topic. Crosby.
So it was released on Tuesday, yesterday, April 22, and the title is President Mahama suspends Chief Justice after setting up committee to probe petitions. And it reads, President John Dramani Mahama has, in accordance with Article 1466 of the Constitution and in consultation with the Council of State, determined that a prima facie case has been established in respect to 3 petitions against the Chief Justice, her ladyship Justice Gertrude Torkornoo. The President has consequently established a committee in compliance with Article 1466 of the Constitution and in consultation with the Council of State with the following composition to inquire into the petitions which have been referred to them. One is Justice Gabriel Scott Poamine, Justice of the Supreme Court, as the chairman of this committee. There's also Justice Samuel Kwame Adibu Asiedu, also Justice of the Supreme Court, as a member of the committee. There's Daniel Yao Domaleba, former Auditor General, a member, and Major Flora Bazanwura Dalugo from the Ghana Armed Forces, also a member of the committee. And the last name on the list is Professor James Sefa Jisa. He is an associate professor at the University of Ghana, and he is also a member of the committee. It continues to say that pursuant to Article 146(10) of the Constitution and in accordance with the advice of the Council of State, the President has, by a warrant, suspended the Chief Justice with immediate effect pending the outcome of the committee's proceedings. Signed by spokesperson to the President and Minister for Government Communications, Felix Kwachiofosu, who is also a Member of Parliament. Helen.
All right, okay. Shall we take a quick listen, though, also to the Deputy Attorney General, Justice Stremsai, and then we'll get onto the phone lines, and then we can also maybe take a quick look at what the Minority Caucus has to say about this. This is still 3FM Sunrise on 3FM 92.7.
Look at the Constitution. Whether or not to suspend the Chief Justice is a question. It's not automatic that whenever a prima facie case is found by the Council of State and the President, the Chief Justice should be suspended. However, there are other reasons why the Chief Justice may be suspended. So, for example, we have 3 petitions, right? And they are made up of allegations which we, the public, are not aware of. Now, the question is, if you have 3 petitions, you definitely will need a lot of time to prepare your defense and your explanation. So I think, in the rule of the head of the judiciary, both administratively and then judicially, it's already a lot of work. And meetings are involved, and decisions are taken, and letters and reading and all. That's a very heavy duty. So to take the Chief Justice in a position where you continue to perform the time also the depending on the set of 3 petitions concurrently, that's probably one of the reasons why the President wants to suspend the Chief Justice, so that you would have sufficient time to prepare and defend yourself against the allegation. Another reason has also been And I'm saying cool because I'm not able to what went on in the Europe in terms of education to that thing, but I'm only giving you some of the possible consideration. It could also be that element of preventing interference with the inquiry. As you may know, the Chief Justice is the head of the judiciary.
3FM 92.7 Urban Lifestyle Radio Station. 3FM 92.7.
All right, and you just heard from the Deputy Attorney General, Justice Shremsai. I attempted to play for you the Minister of State for Government Communications, Felix Kwakye Ofosu. We'll try and bring that audio to you in due course. But before that, let's take a look at what the Minority Caucus has to say about this. They've issued a presser that has some information there for us. Crosby, please.
So this is what the minority group, and I'm talking about the MPP group in Parliament, they're condemning the suspension of the Chief Justice, Gertrude Torkornoo. Their statement reads, the decision by President John Dramani Mahama to suspend her ladyship Chief Justice Gertrude Esaba Saki Torkornoo under the purported authority of Article 146 of the Constitution is nothing short of a brazen judicial coup, a reckless abuse of executive power, and a direct assault on the independence of Ghana's judiciary. He adds that this move, taken while legitimate legal challenges are pending before the Supreme Court, reeks of intolerable political vendetta, judicial intimidation, and a calculated attempt to pack the courts with NDC sympathetic justices, as openly promised by President Mahama in Akosombo in 2023. So this is what the minority is saying. They add that President Mahama's actions confirm what many have long suspected, that this is not about accountability, but about raw political control. His public declaration in Akosombo that he intends to, in effect, balance the judiciary by appointing NDC-aligned judges exposes the ulterior motive behind this sudden rush to remove the Chief Justice. He adds any further attempt to harass, intimidate, or unlawfully remove the Chief Justice will be met with fierce legal and public resistance. Any effort to pack the judiciary with politically compliant judges will be challenged to the fullest extent of the law.
All right, I think that is okay. There's some more.
So I think there's a last one. It says the legal fraternity, civil society, and all defenders of democracy will not stand idly by while the judiciary is turned into an appendage of the executive. I must say I like the writing, I like the wording of the minority statement. Their demands are these. We demand the immediate reinstatement of the Chief Justice pending the Supreme Court's determination of the pending legal challenges. A halt to all removal proceedings until the judiciary has conclusively ruled on the constitutionality of the process. Also, these are the demands that the minority is making in relation to the suspension of the Chief Justice Gertrude Torkornoo, condemning it in all its right and all its forms, Helen.
Certainly. Thank you for that, Crosby. So those are the demands as put forth by the minority in Parliament. They're asking for an immediate reinstatement of the Chief Justice pending the Supreme Court's determination of the pending legal challenges. Also a halt to all removal proceedings until the judiciary has conclusively ruled on the constitutionality of the process. But it's in the Constitution. So why are they asking for the constitutionality of the process?
I think that, you know, and I was referring to an old video of the Lady Chief Justice, that she said that no matter what noises are made, the law is the law. I don't get where people come from when they say that, yes, it's there in the law, yes, it's there on our books, yes, it's something that it's been there, but it's never been done before, so it should never be done. If there's probable cause to prove that the Chief Justice indeed is complicit of the things that she's been accused of, and we don't know. But I'm sure that the Council of State has seen it, right? And based on that, they, you help me here. The prima facie is when you determine that there's something that you can possibly stand on to say, yes. All right, okay. So the Council of State
that there's some question indeed worth
to be answering.
We are not going on a wild goose chase.
Yeah, we're not fishing.
We are not fishing.
Now, if the Council of State, if you look at the composition of the Council of State, right, you have no doubt in your mind that these are people of timber and caliber, as the Nigerians will say. The former Chief Justice, Sophia Akufo, is there on the Council of State, right?
That's right.
And you have other lawyers and other, high-placed personalities in society, traditional leaders, etc. Was it the Chief Justice, the former Chief Justice in the Charlotte Osei matter? You remember she made that determination.
You say former?
Yes, former Chief Justice, Sophia Akufo,
right,
in the
okay.
Charlotte Osei matter.
Right.
She's now on the Council of State,
that's right.
Do you think that she doesn't know her left from her right when it comes to the law, and that she would not know how to play ball in terms of trying to interpret the law? Let's cut her some slack.
And this is somebody who championed the former, the removal of Charlotte.
Exactly.
So she was involved, used that process.
So that prima facie, she, that's what I'm saying, that, look, we should stop talking and creating the impression that the people on our Council of State are some Tibonkosu people who don't know their left from their right. The framers of the Constitution were very much aware that, look, the president would just receive the petition and they will forward it to the chief of the Council of State.
Right.
The Council of State will then make the determination whether there's a question to be answered or not.
Right.
And then based upon that, they will give back to the president. The president will now form a committee. Okay, and now we know that the committee has been formed, suspension has happened, and then the matter will be looked at. All of this should be
right.
National House of Chief has representatives, former CDS, former IGP, former Chief Justice. There are presidential nominees and all of that. Look at the number that they have. And yet they receive the petitions, and not a word of the petition is out there in the public
From
domain.
the office of the president.
From the office of the president to the Council of State.
In fact, the office of the president, there's a secretariat.
Right.
Some secretary would have received this.
Yes. Somebody would have photocoped
it.
Took a screenshot.
Somebody would have done this.
Binding.
And still,
we don't have.
Somebody will bind it nicely because now we have a few.
Yeah.
But I wanted to say that what is a seeming bone of contention, at least for the minority that I've observed, is the issue of suspension. So we do know that the president can decide to take the council's advice or not, as far as suspension is concerned. Now, from certain quarters of the NPP, they're saying that if he's at liberty to not suspend, why has he done so? That has become now another sticking point. You didn't have to suspend Mr. President, but you have. Is that a solid enough foundation to stand on, to have a gripe with the president about this issue of suspension? You didn't have to, but you have.
You see, Crosby and I went through this when the matter started. You recall, we went through the entirety of Article 146.
Right.
And the discretionary power is granted the president in that instance. Because at that point, the president would have been the one with full knowledge of the scope and nature of the allegations to see whether the continuous stay of the office holder in the office. And this is by no way an issue about the current Chief Justice. You see, I started talking about processes.
Right.
So the president would have known, or whoever the president would have been. It's not about Mr. John Dramani Mahama. Whoever the president of the republic would be at any given time would have full knowledge of the facts, because the petition would have been received by the said president. Now, the president would be able to tell, also from the determination of the initial cases, whether there's a cause to answer, would have been able to tell whether, if the person occupying the office of the Chief Justice, the continuous stay of the person in that office would in any way impede investigations, hinder the work of the judiciary. Because, mind you, the Chief Justice is not just a justice of the court of the Supreme Court. It's also the head of the institution with administrative duties and responsibilities. So you are under such a tight, serious, rigorous process, and you are still going about exercising administrative functions. I mean, even in normal, regular public administration, framework systems and all of that, where there's an allegation against you,
you step aside.
You are asked to proceed on leave.
That's right.
If you look at it from that angle, it may help that in the interest of the administration of justice, number one, in the interest of the exercise of the administrative duties, functions of the office holder, in the interest of the integrity of the institution as a whole, the person who so stands accused should step aside. Let the committee do its work.
Right.
The committee, at the end of its work, may exonerate the office holder. The office holder is reinstated. That is why this morning we came so hard at the newspaper that used the word sacked instead of suspend. You get it? So, I mean, if you look at it in that sense, then you would have no problem with the constitutional provision that says that the president may or may not remove the Chief Justice temporarily as the work continues. Now, if the president decides to exercise that discretionary power to remove the Chief Justice temporarily, it would mean that there is something that the president has seen reading the entirety of the documentation that is before him.
Right.
And based on the advice of the Council of State, that we cannot continue to let the office holder remain in office in the meantime. How long will it take for the investigations to go on? I will stand with the minority in Parliament. If the minority points out that there would have been another way of handling this based on the facts available. But in this particular instance, none of us, nobody, the minority doesn't have the facts. You and I in this studio, we don't have the facts.
Right.
The Chief Justice is the only one who has the facts.
So when the minority says that the constitutionality of the process is questionable, what foundation are they standing on to say
that's
so?
where the
They did not
confusion.
cite any provision.
That's where the
Sorry.
confusion comes from. Because see, Alexander Penyomake himself is a lawyer. Vincent is a lawyer. I doubt that if you read Article 146 from the beginning to the very end, you will find any of the processes or the steps taken so far to be averse with what the law says. The law is very clear on what should happen if anybody at all petitions the president for the removal of the Chief Justice, or even the president himself. If somebody sends a petition, there's a process. It's stated clearly in there. So it would have served as a great deal if the minority had come forward to say that you took this step and it was wrong. You took that step and it was wrong. And based on that, we can then say that you have a preoccupied position of trying to do A, B, C, and D. You don't like, because all what is happening is just emotional. So far, nobody has spoken about the law.
Is it emotion or is it politics?
Indeed.
Say again,
The Constitution
Emotion
talks
or
about-
politics?
well, there's
Or
emotion.
emotional politics?
Emotional politics. But you see, so far, nobody has raised the question of law, really. Even the lady, I forgot her, the lady doctor, the lecturer at Gimpa, I forgot her name, slipped me, but she was on Newsfile, over the
on
weekend.
Saturday, yeah.
Even she agrees that, look, it is the law. It is in the law. However, because it has not been implemented before, we should not touch it because it's just there for the optics. Literally. I mean, when she says it's there for in theory, but not in practice, which I find very worrying. So that in future, if we have somebody who comes to hold the position of president and uses that position to do overt stuff and covert stuff that are not good, but we say, oh, because a president has not been impeached before, let's not. Is that where we are going? we should be able to let everybody know that nobody is above the law. Is that not what we say every time?
Absolutely.
So if the Chief Justice is very confident that, look, in that old video I was referring to, she said in that video that whatever decisions she has taken, whatever standing up she has been able to give, whatever staying above the water she has been able to survive, it is because she had fidelity to the law. If she has fidelity to the law and she has not done anything wrong and she's very confident about it, the committee is there, appear before the committee.
So are we jumping the gun? Because at this point, nothing has happened.
If you are not...
No, but to be fair to her, Johnny, I don't think she has... Maybe she said it within her circles, but she has not publicly expressed any disagreement with...
I agree with you. But you see, where consistently you have people coming forward to say, oh, don't take her before it will crash our system, don't take her before, don't do this. It raises certain questions. What do they know that we don't know?
You know, there's also the Constitution talks about the exercise of that discretionary power, which is also another reference that people are quickly relying upon. That the exercise of that discretionary power or authority must not be whimsical or capricious. It must be fair, and the Constitution uses some pretty firm words there. So now we come back to the facts as we have them. I'm willing to call out His Excellency John Dramani Mahama to say that, look, the Constitution says this, but the facts available to us show that you are doing this. And then we all can have that conversation and call out the president of the land. We've done that before on this show. But as I keep saying, there is nothing that suggests to us the president has been whimsical in his exercise of the discretionary power given him by the Constitution. There's nothing available to us that shows that he's been capricious, and like one headline says that it is retaliation. There's nothing to us that suggests that this is purely and simply an NDC propaganda or orchestration, being championed by the president for whatever reason. We don't have that evidence. And I'm saying that I am unable to agree with the minority, and for that matter with anybody who is questioning the processes so far, procedures so far, the exercise of that discretion so far as given by the to the president by the Constitution. I'm unable to agree with them because there's simply no facts available to the contrary. There's nothing that shows that this is some personal vendetta or this is some that the issue is really not there, but then Mr. President is making what do they call it, a mountain out of a mold. There's nothing that suggests.
If you listen to the minority statements, what we read, I mean, just to maybe get your attention on that. So they said, based on what the president said in 2023, and they put it as the president attempting to balance the composition of the Supreme Court.
No, I get that, but I'm saying that, okay, so the president made that statement. We played that tape here, and we discussed it thoroughly, and we said it was not an appropriate statement to have been made. I said that at that time. I cannot go back on my word, but I'm saying that in the present case, as we have it, the facts that we have, is there anything that suggests that indeed this is a move towards fulfilling that whether promise or pledge or commitment or
but really, how would one person being off the bench change anything? If you look at the current composition of the Supreme Court bench, right? Justice Poaman came in 2015, right? John Dramani Mahama, and then Justice Paul Bafoboni came in 2008. Ketsi, President Kufuor. The rest are all President Akufo-Addo's appointees, right? So if you take away her ladyship, the Chief Justice, Justice Torkornoo, of it, what will it really change?
So
for me, I think the bigger conversation should be...
It will change a lot, too. That's the head of the institution.
Well, but if the head of the institution changes, and then the people you will still empanel are perceived to be people on one side. Yes, the point is that...
Maybe the head can whip them in line.
We need to... one of the advices that Professor Azar gave... the Justice Bafoboni, future CJ, he's acting now. He said, look, some of the things that we saw in the past, don't repeat them, or if you repeat them, you'll be in trouble. Your fidelity should be to the law, your fidelity should be to the people, and your fidelity should be out of respect for the members or on the bench that you chair.
Thank you, gentlemen.
Choose the Constitution, even if it will cost you, and it will cost you.
Not always succinct, but always impactful. We're going to put some more flesh on the bones to this conversation. 2 minutes to the top of the hour.
Dr. Jonathan Asante-Ottre is a political scientist. Doc, good morning. Thank you very much for your time. Hello, Doc. Good morning.
Good morning.
Great. Now, there's a lot of talk in town about the suspension of the leadership of the Chief Justice and the committee that's been formed and all of that. From a political science point of view, are we not talking too much? Or is the talk necessary now in order to shape the decisions that eventually will come out from the committee? What do you say?
Well, let me say good morning to your good self and your listeners once again. You see, I foresee a situation where most, or if you talk about the minority, preempting possibly what is to happen, and it's making their views more partisanly led than just merely talking law, especially those from the legal fraternity. They seem to have poisoned the environment so much to the effect that, as you rightly asked, is it just mere ugly noises, or we are trying to speculate to determine what is likely to happen, even before the case is determined or heard. And for me, that does not really augur well, for the political terrain, the serenity of it, and so on and so forth. By and large, I think that the presidency, the Council of State, they have really, really conducted themselves very professionally. And I'm of the view that they are constitutionally guided and that the procedure has been fair on both sides. And that, for me, is more important than anything else. As to the arrival of an acquittal or a discharge of the Venerable Chief Justice from office, that one is for me, much ado about nothing. Until you get there, it is all about speculation.
I see. Let me bring in Council Osman Alasan. Council, good morning. Thank you for your time.
Good morning, and good morning to your listeners.
Press conferences are being held. In fact, the minority held one yesterday. We've seen the Christian mothers also issue a press statement suggesting that if we don't take care, we may crash our judiciary and we may be doing something wrong to set the wrong precedent. First of all, let me ask you, is any law being broken here by the processes that have been set in place and subsequently the suspension of the Chief Justice?
Thank you very much for having me. Let me first say that sometimes I think we sometimes are a bit hypocritical. Okay, we have
Sunrise on 3FM.
A lot of history about the removal of someone who is at the status or who is at the status of a superior court judge. Now, the Constitution has made provision for something. Now, let's all know that the occupation of the office of the Chief Justice is not a carte blanche for the Chief Justice to do anything he or she pleases in that office and remain in that office. The Constitution did not contemplate that. And so the Constitution has made provision for the appointment of a Chief Justice and had made provision for the removal of a Chief Justice. Now, if the grounds for which the Chief Justice is being removed are deemed to be unfair or does not constitute grounds egregious enough to constitute her removal, that may be a different conversation. But we don't know the content of the petitions that allege removal of the Chief Justice.
Right.
And so I don't understand the context in which anybody would argue that, some law is being broken or some unconstitutionality is being entertained in this process. Now, this is not the first time this process has taken place in this country. It has taken place against Justice Aban before, Apollo, Justice Aqua, and so many others. Well, it did not come to this stage as we have it now. But it's not the first time. Attempts have been made to remove the Chief Justice before. And attempts have been made to remove judges or officers of the Superior Court of Judicature before.
Right.
And some have been removed, actually. So it is not when people are crying that we are doing something untoward to our judiciary and that something unlawful is being done, I get a bit conflicted or frustrated because, look, those people were there. Those same people were there, and we never heard a word when Charlotte Osei was being removed. And let's all remember that the chair of the Electoral Commission is just like a Court of Appeal judge. Now, a Court of Appeal judge is a member of a Superior Court judge. And so the Constitution says if you want to remove a Superior Court judge, these are the grounds, and this is the procedure to remove the person. It's not like when you become a justice or a member of the judiciary, or when you become a Superior Court judge, then nobody can touch you. No, that's not what the Constitution contemplates. In fact, the Constitution has stated grounds based on which each person will be removed. And those grounds are simple. 3. It said stated misbehavior, incompetence, or inability to perform the function of your office due to physical or mental disability.
Right.
All right. So let's take the last one out. Stated misbehavior, incompetence, which means that a Chief Justice or a a Superior Court judge is not entitled, no matter the protection the Constitution has provided for them, they are not entitled to misbehave. They are not entitled to demonstrate incompetence for the function of the judiciary, because it is one of the cardinal places, institutions that hold our country together, that hold to which the public actually look up, you see. And so they don't give them the opportunity to do as they please. And so if the law is being followed, okay, they say if someone makes a petition or brings a petition for the removal of the Chief Justice, the president shall do certain things. And this is the Constitution speaking. It is not anybody speaking. And it's not speaking to any particular president, or it's not speaking about any particular Chief Justice or Superior Court judge. It is general. So if the office created, the terms of the and conditions of the office are also created, and the removal from the office is part of the conditions, terms and conditions. And so the Constitution says when the petition is presented, the president will have to establish a prima facie case in consultation with the Council of State. And that is what the president has done.
Great. Let me bring in Dr. Santiotri. Doc, now, with all these talks going around, it does present a certain, if you like, idea that the Council of State may not be fit for purpose, because if the Council of State, given the caliber of people seated on it, have, in consultation with the president, found a prima facie, which will mean that then a committee will be set up and then suspension will happen for the Lady Chief Justice to appear before them. And people are already saying that they may have gotten it wrong. They had, what does that say to you of the Council of State? That they are not fit for purpose, or what?
Well, I think that sometimes we take politics to a certain level that becomes a disincentive, if you ask me. I mean, you want to tell me that the former Chief Justice is a pushover? Can anybody convince me that Cletus Avoka is not solid enough? Or because he's an NDC person? What about Durajaho? I mean, and you have other people who are solid at that place for now. Until proven otherwise, it is very unfair on the Council of State that a communication would put out there as though they did not do any better work. You see, I think that the main problem is the procedure itself. The procedure that allows for secrecy instead of transparency create all manner of suspicion. Those who have opportunity to speak on air tend to obfuscate the issue before the real issues even come out. If indeed what Mr. Samidefu put out there on a sister station to the effect that this is one of probably the misconduct, you see, that particular allegation that has found expression in the petition would definitely have to come from an insider. Because I mean, in terms of the traveling thing, it is a policy, this is what you must do. And if you went against it and later on you are trying to refund or you refunded, you have already misconducted yourself. So, the unfortunate thing is that we do not have before us the content of the petition. But if, for example, the minority leader says that, oh, it is frivolous, the petition is frivolous, should I assume that he's seeing the content of the petitions? For which reason he's come out with that conclusion? Or it is just politics, partisan politics as usual? Then when the entirety of minority seem to have waded in and backing the woman, bastardizing protests, insulting everyone, abusing everyone here and there, do they want us to believe that the Chief Justice, the Venerable Chief Justice, is an MPP person? I don't know. But the way I'm waded in, so when you do that, then the NDC section will also have to wade in, because they think that then you are poisoning the environment against the government, and it becomes what? A polarized position. That being said, before you asked me of the first question, the minority cited President Mahama as having said that NDC lawyers should. No, I think that particular communication out there is a miscommunication. What the man said, and I don't know why the NDC communication would just sit idle and not straighten up that particular thing. It is the same thing like this, what's it called? Before he lost the elections in 2016, where he said Ethiopia.
Right.
I mean, look at how that was twisted. The 2-4 is celebrating his birthday, and they played that song, and the minority then takes up that thing and goes to market with that, saying that the struggling Ghanaians, what they are going through, the president says that they are not listening to anybody. Then everything is left with bones, and then it is twisted, and they sit there and will not communicate. This one, what the president said then was that lawyers who belong to the NDC fraternity must be interested in what? Getting into the judiciary. If they weren't going to offend them, no. He said they should be interested because there is a perception out there in the public domain that on a regular basis, the then president was what? Filling the judiciary with people who align themselves with their party. So why wouldn't they also be interested in getting there instead of only following private parties? So if I come back to the minority, for example, saying that the vote is frivolous and other things, so I find out, does that mean you have seen the petition? So if that is the case, this secrecy thing that I'm talking about will fuel speculation, misperceptions, people saying all manner of things until the chickens come home to roost. We wouldn't know. So people will just be engaging in the politics as usual is then going to turn into some kind of partisan, football.
I see.
And that will make the Chief Justice look very awkward. To make the Chief Justice look very awkward. Because why is it that only this section of the public or the society are backing you, and the other side they are against you? It makes her look very awkward. And the manner in which Supreme Court has been operating over the years, if a case will not even be heard for 3 years, and a particular case within few hours could be heard, I mean, all this is do not in any way appear well for the image of the judiciary.
Well, they say the wheels of justice grind slowly. But let me bring in counsel. Counsel, your own Ghana Bar Association is yet to speak a word regarding this matter. In fact, when the issues of the petition came out, the fact that some people had petitioned the presidency, the GBA has not said anything. We've seen the process travel through Council of State, prima facie established, Chief Justice suspended, somebody is acting now, Justice Bafuboni is acting, and the GBA is quiet. Are you surprised that they are quiet?
Well, I'm not surprised. And I think their silence at this point in time is very appropriate. One, because, as I said, nobody is appraised with the facts underlying the process. The content of the petition, GBA, is to be deemed not to be aware or not to know the grounds based on which this procedure is being triggered. And so if the GBA is going to say anything, what is GBA going to say? Number two, the silence of GBA also should tell us that there is nothing unlawful that the president has engaged in yet. We know the GBA, and we know how vibrant it is with upholding our constitution and executing or upholding our laws. To sometimes go as far as Supreme Court to challenge the decisions, some of the decisions of presidents. We know that. And so for me, their silence at this point in time is very, very important. And I pray, I hope that they remain silent until at a point where they will be seized with all the facts and now can judge that if the facts are these, then the decision shouldn't have been that. That is the point at which they should make a pronouncement. Because for now, the procedure as the Constitution prescribed is what is being followed, and it is being followed strictly. There's nothing that has happened that constitutes violation of any constitutional provision for now, in my opinion. And so, that is corroborated by the silence of GBA. And so I am not surprised that at this stage, GBA has not made a statement, and it is proper that it doesn't make a statement for now.
Well, not a statement on the merits of the matter, but a statement on the processes. I mean, we've had other groups who may not have immediate vested interests in all what is going on making statements. Christian mothers are making statements. The minority in parliament is making statements suggesting that they are protecting the independence of the judiciary. The GBA works within the judiciary infrastructure. Do they not have an opinion as to whether the process is right and that we should all lie down and allow it to happen, or it is wrong? They must have a position, not on the merits of the matter, but on the procedural issues. Yes?
So, you see, the groups to which you made reference, I should say they might have lawyers among them, but they are not known to be a law society. Okay? And we can safely presume that they don't understand the legal process or the constitutionalism we have chosen for ourselves. And if they do, so two things will inform whatever statement they are making against the process. As I said earlier, there is no any unconstitutionality in the process. There's no illegality in the process. But if people think that statements must be made against the process that has been laid out and is being followed, laid out by the Constitution and is being followed, two things might have grounded that: mischief or ignorance. In either case, is dangerous for our democracy, because if you want to do mischief, why I say it is mischief is because there is no basis. If someone is saying that this process that you are embarking upon is against this law or is against this particular constitutional provision, then it gives us cause to all exercise our brains and see how inconsistent the process is to that particular law or that constitution. But in this case, that's not what those societies or those groups are alleging. They are not alleging any constitutional infraction. They are not alleging any illegality. They are simply saying that the process should not have been initiated. And that is in itself is an implicit overthrow of a constitutional provision. Now, the very Constitution that confers the right for you to exercise in that manner is the same Constitution that has laid down a process by its own provision for it to be followed. And if those provisions are being followed strictly and you find problem with it, then it means you don't deserve the right that you are exercising, which is conferred on you by the same Constitution.
I see.
And so for me, it is either ignorance or mischief, and we can't make comparison between those societies and the Ghana Bar Association, because this is a group of lawyers, and the president of the GBA, which is the mouthpiece of GBA, is a lawyer. And so he understands and must be deemed or presumed properly to understand how the law works and to understand the law in its entirety. And so if GBA is not commenting, is not saying anything, that should have even served as a guide to those societies who are not law-based to also exercise some restraint for now.
I see. Dr. Autry, let me bring you in. So there's also the talk about setting a very bad precedent for the future. You are the political scientist. Does this then open the floodgates or kind of worms for other positions that are protected, so to speak, now to come under scrutiny? And if you will, if there's a change in government, can a president then come and say, I don't like this EC, I don't like this CJ, I don't like this person, and changes everybody, and then that's it? Are we heading towards that direction?
I think that one is a very lame excuse and a lame reason. Why is it that Madame Theodora Woods was not removed? when there was a change of government, or this process was not initiated against her. In any case, there were some petitions that were leveled against her, but it did not meet the threshold. Now, before I even go into that, let me quickly react to the other version of the GBA. I think that if GBA should come in now, they will receive a huge backlash that they will regret ever.
Oh, why?
We have been in this country, yes, we've been in this country, where issues of legal importance, issues of, rule of law have been abused and other things that they did not pass a comment. This is not the time for them to do so. They will receive a huge backlash because it will appear then that when they say that they think towards a particular direction, then it is true. And a normal circumstance, this should have engaged the minds of the GBA. No two ways about that, because it affects their fraternity. But the judiciary is not an arm of the GBA. No. It is an arm of government, a state apparatus for that matter. But because it is affecting the office of the Chief Justice, appropriately they should have spoken about it. But because they have a very bad reputation and a very bad record in the past, that is why they are a bit hesitant. Yes, they might
are you not being too hard on the GBA?
Johnny, ask yourself, when 8 people were extrajudicially killed, is it 8? Yes.
Yes, 8 in the 2020 elections, yes.
Yeah. What was their comment? Did they say anything? This involved murder, human beings being killed. Human beings being killed. In the same way, I've never heard them say anything about the 2024 elections in which some people were killed in the same manner.
That's right.
So you see that if that is their consistency, then Aristotle will tell you that that character should be consistent. Even if inconsistency is your character trait, then you must be inconsistently consistent. And if consistency is your character trait, then you must consistently be consistent. You cannot be picking and be choosing, especially when one foot is affected. No. Probably I will also go by counsel's reasons that he gave, that they don't even have the full details of petition. So we should assume. But it is possible that others do have it. But because if they come out with it and speak plainly about those issues, that would have meant that somebody will have broken the oath of secrecy. So that is just by the back. And the question that you asked, whether you are setting a bad precedent, it is possible. But every issue comes out with its own merit and demerit. That is why I started by saying that Madame Theodore Woods, the longest serving Chief Justice for that,
right?
Transits 2 different regimes, even 3. President Kufuor, President Mills, and President Mahama. There was not a scintilla of allegation of bias or of impropriety against her. The only thing I saw was this girl land and all those, but I think that it did not meet the threshold of a prima facie, for which it was thrown somewhere else. And she had peace of mind to go through her office and then ended quietly. Can we say the same about Justice Torkornoo? Well, that's right. That will mean that we are going to go into the merit or the demerit of administrative conduct. Because for me, I've always had a problem with her saying to me that my birth certificate, through a ruling, my birth certificate that bears the name of my mother and my father, who themselves are Ghanaians, does not in any way make me a Ghanaian. Then I don't know which other logical reasoning, just a new document, which is Ghana card, can determine my Ghanaianness or otherwise. And you saw how she even had to struggle to defend that during her vetting process. So it's as if they must reason in a certain direction. Other than that, their independence will be compromised and so on and so forth. Look at this, the last minute thing that Mr. Fenyimakins did before the 2024 elections. And I said on your platform that the way the Supreme Court is getting embroiled in things that are partisanly led it will create a problem of image for them. And that it is not everything that they should be entertaining. Because at the end of the day, their image will sink. And that, unless they explain that issue in a technical manner, I don't see how in any legal gymnastics they'll be able to explain and convince me. Because law is just about common sense.
I hear you. Thank you very much, Dr. Jonathan Asante-Ottri. We're grateful for your time. Council, you have the closing thoughts on this one. So now the committee has been set, the Justice Poorman Committee has been set. The Chief Justice is expected to go before them to also get her side heard, if you will. How should we as Ghanaians entirely, those who agree with the process, those who disagree with the process, those who are sitting on the fence, how should we be conducting ourselves going forward?
I think the best way is to, is to be legitimately expectant, but we should be cautious in the comments we make, because this process can be likened to any judicial process. They will be hearing the defense of the Chief Justice, and they will be hearing or taking some more evidence from the petitioners. So, and although this is going to be in camera, you know, we are not supposed to see the process. And so we are less opportune to even make any comments about the process. And so what I would say is that Ghanaians should be a little more cautious, and let's watch and see the outcome of the committee's work. All they need to do is to inquire further into the matter, bring their report, make recommendations to the president, and the president will act in accordance with the recommendation. The president will have no discretion, because he shall act in accordance with the recommendation of the committee. And so after the work of the committee, definitely it will be out. The grounds for the decision or recommendation of the committee will now be out, and Ghanaians will have the opportunity to exercise their preferences and their contributions to the process generally.
Thank you, Lawyer Osman Alasan. We're grateful, Council, as always.
Most welcome.
Wamba lumba, wamba lumba, wamba lumba, wamba lumba, wamba lumba, wamba lumba.